Last week, the same justice chose not to uphold the ruling of the very judge they appointed. Everyone agrees the Supreme Court's ruling is very flawed and dishonest. As a result, the legal process will continue to move forward. At the end of the day, we will be successful. While the legal situation continues to be unclear, the guidance I am given by the Alabama Constitution is very clear. The local constitutional amendment passed overwhelmingly by the voters gives my office and the office of the district attorney the role to determine all rules and regulations regarding the operation of bingo in Macon County. We will take this responsibility very seriously. For the past several months, VictoryLand officials have been working around the clock to reopen. They are in the process of finalizing vendors to offer electronic bingo machines, and we will have a careful review, unlike the Alabama Supreme Court, to determine if these new machines meet the guidelines set forth by Macon County. Facts, not politics, will drive our process. I am not a lawyer, I am a lawman. And I say again, I am a lawman. But I can tell you that the ruling last week, which will be appealed, is not worth the paper it was written on, according to every lawyer and knowledgeable person that I have talked to. Regardless of what the Supreme Court said, the district attorney and myself take our role in this process very seriously. And we plan to ensure that the law passed by the Alabama legislature and the Macon County voters is met and our people are treated fairly. Thank you.
Good morning. My name's James Anderson, and I represent Sheriff Brunson, and I want to share with you a few things from a legal perspective, and I'm not going to bore you with citing the cases. After we get through here today, I've got a little handout that I've asked people that'll have some specific cases in it, but I want to talk about some things that the sheriff mentioned from a legal standpoint where we think this opinion, which is not final, and I understand that VictoryLand is going to file a rehearing on. And I want to tell you from the very get-go some of the flaws from this opinion. The court mentioned at the beginning of their opinion a doctrine that we've had in Alabama since common law, over 200 years. It's called the ore tennis rule. Now that just means spoken testimony. When you have a judge that tries a case without a jury, as Judge Shashi did, and he makes factual findings, those findings by the appellate court are not to be questioned. That's the law in Alabama, plain and simple. I'll give you an example. If you've got somebody that says it's daylight, that testifies under oath, it's daylight, and somebody that says it's dark, and the judge has to make a decision. Our courts say the judge is looking at the witnesses. He's taking in account their credibility, just like a jury does when somebody has conflicting testimony. And if the judge in the example I gave you says it's dark, the appellate court can't come in and say, well, the judge was mistaken because this witness said it was light. What they've said in this case is Judge Shashi could not consider the actual evidence that was presented to him about this case. Now, it was uncontroverted in Judge Shashi's case that in this county, in 2003, it was without a doubt, everyone knew they were voting on the possibility of electronic bingo. There was no reason at that time for anybody to think that Macon County was going to have economic development because they were going to just have paper bingo with ladies covering numbers with butter beans. In fact, those of you that were here know what went on and how contentious that election was. There was evidence, and it's uncontradicted, that the people voted knowing they were voting on electronic bingo. The people that opposed it, that ran ads, the Christian Coalition said, you're going to be bringing bingo, you're going to be bringing casinos to Macon County. And sure enough, when it passed, they did. We got feedback. Is it because I'm so mad? No. Somebody's microphone's not bad. But when they said Judge Shashi could not consider what the newspaper said, It said it couldn't consider what the people testified to. The Supreme Court went against 100 years of precedent. And I've got some cases that I'm going to have when I hand out. I'm going to put my glasses on so I can read this. I want to get this quote straight. Here's a quote from the Alabama Supreme Court in 1897. There can be no just construction or interpretation effectuating the intent of the people, which is not deducted not only from the words, but from the history of any particular part or provision of the instrument. Now we're talking about the Alabama Constitution. Now I'm going to read you another quote from some guy that I'll tell you who said this later. On every question of construction, carry ourselves back to the time when the Constitution was adopted. Recollect the spirit manifested in the debates, instead of trying what meaning may be squeezed out of the text or invented against it, confirmed to the probable one in which it was passed. That's some guy named Thomas Jefferson that said this is how we ought to interpret the Constitution. You can't squeeze out of the text or invent something. The court, in this case, looking at the history and saying that Judge Shashy couldn't look at this, I'm going to read a case that's over 50 years old. It says, it is permissible in ascertaining their purpose and intent to look at the history of the times, the existing order of things, the state of the law when the instrument was adopted, and conditions necessitated such adoption. The court went on to say it's proper to look at contemporaneous written materials, including newspapers, in studying the history of the times as an aid to the constitutional interpretation. Certainly statements in the current press of the time can be considered. That was in 1955. They've ignored all that when they told Judge Shashy he could not consider that in 2003 the people that voted on this had newspaper articles, had advertisements. There was debate over the passage of this. There's no question that electronic bingo had been in existence for more than 2 years before it was passed. And I've told the sheriff is going to follow orders of the court and the local law enforcement people here. But right now, this is a flawed opinion. I expect VictoryLand to ask to reconsider, and then they've got options of going to federal court because this case is so against anything that we've had historically. I thank you for coming. I'll take questions later.
Good morning. My name is Judge Alfonso Menifee, Macon County's probate judge. Today I want to share a few particular points about the decision that the Supreme Court made. I want to also discuss the unholy decision that they made and how it came about. First, to be clear, the Alabama Supreme Court did not make a judicial order. They made a political order. This charade started 7 years ago when former Governor Bob Riley was paid to shut VictoryLand down by a particular interest in Mississippi that gave him monies to do that, and he has done just that. An investigation is taking place by the U.S. Senator John McCain to prove that Bob Riley took millions of dollars from the Mississippi Indian tribe. Bob Riley continues to own Alabama Supreme Court. Wow. They move every time he speaks. It is obvious, ever since he left office, that every time he goes to them, the decision is always rendered in his favor, irregardless of the circumstance. Everybody already knows when the decision goes to him, to the Supreme Court, what the answer is going to be. You may ask why. Many of the judges have received significant money from the sources controlled by Bob Riley. Also, in the closing of his term of office, he transferred $25 million from the State Highway Department Road and Bridge Fund. This has never been done in the state of Alabama. Never been done before. Finally, I'd like to say that anybody, including Bob Riley, or anyone else, or any entity, that choose to close down an operation with 2,000 people working in a poor county like Macon is an evil individual. And I thank you.
Good morning. My name is Andy Hornsby, and I'm a proud native of Macon County. I want to speak to you briefly today about fairness, about protecting the will of the people. Like every other Alabamian, we are sick of political games that have been played by high-ranking political officials with the people of Macon County and East Alabama who depend on VictoryLand for their livelihood. Alabamians are fair people, but we want our politically elected officials to treat us fairly. How fair is it that the Poach Creek Indians, 20 minutes from right here, are running 2 major casinos? Yet some in the Montgomery political establishment deny that right to Macon County voters who approved that action. How fair is it that VictoryLand was illegally raided and tens of millions of dollars of taxpayers' money spent on those raids and everything after that to keep us shut down? Yet no action has been taken by anybody to prosecute anybody from that illegal raid. Remember, they only had a search warrant. They came in here to search the place and destroyed it. How fair is that?
That's happening. As you know, we started working 16 to 18 hours a day several months ago to get VictoryLand reopened. The process has been ongoing and still is, and it's been slower than we have all wanted for several reasons. One, we started in West Gaming initially. That's where we've been working. Most of the work has been going on over here because that's the first place we're going to open. Once we got in and got our contractors in there working, they realized the damage was much, much worse than we had ever anticipated. We had to have new wiring, unexpected construction was required, and it's shameful the way Luther Strange and his people treated our facility. Shameful. There's no other way to say it. Secondly, in our negotiations with our vendors to get equipment, and primarily electronic bingo machines, we come to find out that Luther Strange had forced a memorandum of understanding, an illegal, I might add, a very illegal memorandum of understanding on our vendors. This whole process was clearly designed to blackmail our vendors and to keep them from doing business with us. However, he didn't use the same application to the Native Americans. They were exempted in these memorandums of understanding with our vendors. And ironically, last week, as y'all know, the U.S. Attorney issued letters to Luther Strange and asking him a series of questions, not the least of which was about these memorandums of understanding, which it is real clear when you read that letter that he realizes, in my opinion, and this is my interpretation of the letter and a lot of other people, that those memorandums of understanding are illegal. And they were forced on the vendors by none other than Luther Strange. That's wrong. As it's already been said, this corrupt ruling is certainly not a legal ruling. It's a political ruling, and I don't think anybody in the state was surprised knowing the relationship between Luther Strange and the Alabama Supreme Court and Bob Riley in the Alabama Supreme Court. I don't think anybody was surprised by the ruling. Now for the good news. We're in the final stages right now of getting this facility in first-class condition. And again, it's taken us considerably longer because of the reasons I've just given you to get there. We've been working very closely. We will continue working closely with the sheriff of Macon County, with the DA of Macon County to ensure that anything and everything we do at this facility is in 100% compliance with the Alabama Constitution and also with the rules and regulations that have been established by the sheriff of Macon County. And there will not be a machine put in this facility until they have been tested by one of the leading electronic machine testing companies in the world. There's two that really stand out, BMM and GLI, and every machine that goes in here will be tested and certified as to what they are in terms of what kind of machines they are. Bingo. We will have, in the final analysis, once all that's done, we'll have some of the same machines that the Native Americans have in Wetumpka, Montgomery, and Atmore. They still have machines that they took off this floor when Luther Strange illegally raided us that have VictoryLand stickers on the side of the machines. Wow. Now, nothing speaks louder than that. The machines didn't change their characteristics when they were put on a truck loaded out of this building and carried to Wetumpka, Montgomery, and Atmore. They're exact same machines. So that says volumes. We have been treated so unfairly, and the people of Alabama, as has already been said, they realize, not just the media, the public. I've never seen a reaction by the public on anything I've ever been involved in my entire life like the reaction of how VictoryLand and Macon County have been and are being mistreated by the system. It's so obvious that there's all kinds of federal laws being broken by certain people, and it just cries out to be corrected. And I think you will see that happen. If you wondered where my lawyers are today, they're in a conference room. They've been there since Thursday afternoon. And I can assure you there will be a legal plan that will be very effective because we got the facts on our side. At the present time, we have a little over 4,000 applications that's been turned in here. And that surprised me, the number did. I figured we'd have probably 2,000, 2,500. We got over 4,000. And I want to name the counties that we have applications from. Other than Macon, obviously, it's Lee, Russell, Tallapoosa, Elmore, Autauga, Montgomery, Bullock, Chambers, and Randolph. We fully intend to have employees from every one of those counties. We've had them in the past, and we're going to have them again. As it's been said already, Alabamians don't like to see people be mistreated. That's a characteristic. I was born and raised here, been here all my life. And even if you don't agree with somebody from a political standpoint, when you see somebody being mistreated, that doesn't sit well, because if you're mistreated, the next person, if someone's mistreated, you may be the next. So we're going to change that. Our mistreatment is stopped, totally. Those doors right back there are going to be open very soon, and very soon. And there's about 1,000 people that's unemployed right now that's going to be employed right here in the coming weeks, and gainfully employed. And I might add, that's just a start, y'all. That's just a start. But you got to start somewhere. Just to give you a little reminder, in 2003, we started with 300 electronic bingo machines upstairs. 300. When we were illegally shut down in 2010, we had over 6,000. But it took that time to build up. And the public will demand how many machines we have. We don't make that determination. The public will tell us how many we need due to the popularity of what we have to offer and how good a job we do in looking after our customers. I don't know how many that'll be, but however many it is, that's what we're going to have, whatever that number is. And we're going to give the Native Americans some competition. All right. I'm not opposed to the Native Americans. I'm opposed to being mistreated. So, and we don't run from competition. We enjoy competition. I think the right amount of competition is good. It's good for the public. It's good for the businesses. And there is a big difference. We pay city, county, and state taxes. All right. Our competition doesn't, and that gives them a big advantage, a big leg up, but they're not breaking the law. Let me be quick to point that out. That is the law. They're not required to pay city, county, and state taxes. And they've got nice facilities, and I'm proud for them. Whatever they're entitled to under the law, that's what they should have. And I'm just looking forward to competing with them. And it's a shame and disgrace that the tens of millions of dollars that Bob Riley and others have spent fighting Macon County is so wrong. I mean, that is an absolute shame and disgrace. And hopefully, I don't know where, I have no idea, no more than anybody in this room, where the U.S. Attorney is headed with his letter and what he's looking at. I don't have any idea about that. But I hope he uncovers every rock and everybody that's done things that's inappropriate, and deals with them accordingly. And I think that'll happen. I truly believe that'll happen. But again, we're looking forward to employing people, paying our taxes, helping education, helping health care, helping charities of all types, and doing the right thing as we've always done, and getting our rights restored. And the people on that court, and on the Alabama Supreme Court and Luther Strange, should hang their head in shame for the way they've treated this business, this county, and the citizens of Alabama. This doesn't just apply, as you heard, the counties we've already had employees from. We're going to have them again. This is so wrong that I think you're going to see some real scrutiny come to Alabama and some of these officials. So, as James said, we'll be glad to take questions. Mr. Gamakerta.
Milton, how did the machines that were confiscated during the raid get from here to the PCI facilities? Were they returned to the vendor, and the vendor then supplied them to the PCI facilities, or did they somehow get confiscated here and end up at the Indian receipts?
The Attorney General, under his illegal memorandum of understanding, allowed them to pick the machines up here and carry them wherever they wanted to in Alabama, as far as if it was Native Americans, or they could take them out of state. So the vendor actually carried them over there under the blessings of the Attorney General's office of Alabama, Luther Strange.
These are not the machines that were part of the ruling last week that authorized the state to destroy them? Was this from a previous?
Oh, no, that's from a previous. No, you're exactly right, and that is confusing. The machines that we're talking about is sitting over there were under a previous rate. Now, the machines that they ruled on last week, we wouldn't use one of those machines if they returned. I want our money back, because that's our money. But the machines, we wouldn't use them because they're obsolete.
Do you have the newer machines on your facility right now? Are there some behind that wall?
No, but we got them coming, big boy. I promise. I promise.
Is that problem resolved that you had with your vendors who felt intimidated by the Attorney General and would not give you machines up to now?
No, sir, not with everybody. It's a good question. We still have 2 or 3 vendors that are intimidated by this illegal agreement. And that's another reason I am so delighted when I picked up the paper and read about the letter that the U.S. Attorney had written. I had no idea that anybody was even looking at these illegal agreements. Let me tell you what I call those agreements when they came out. Every one of my lawyers tell you the same thing. I called it what it was. It's an extortion agreement. That's all it was. That's all it's ever been. It's illegal. And now we got somebody with some clout in law enforcement that are taking a hard look at that. So, but that's an excellent question, because that is confusing, because there's been 2 raids where they got machines. Right. I'm sorry. Yes, ma'am. Hey, Jim.
Mr. McGregor, are you concerned that you're going to be raided again, or do you feel like you've gotten the buy-in from state officials based on some of the letters that we've seen?
I'm not concerned at all, really and truly, because I know we're on the right side of the law, and we're going to stay there. And I know that we're going to comply with the Constitution. We're going to comply with the rules and regulations of the sheriff of Macon County. And we're not going to comply with an illegal ruling by a corrupt court, okay? We're not going to comply. We're going to do what's right. Yeah, okay.
The sheriff is making it clear. Milton mentioned the testing of the machines. The sheriff has asked GLI, the testing institute, and he's demanded that all these machines be the same games and same machines, same bingo that the Indians are playing. And so he's comfortable when they get through his required testing that everything's going to be legal. We'll do the same games here that the Native Americans are doing.
Mr. Anderson, as you know, we've seen these tests 2 times in the past after attempts to reopen after raids.
And you probably see them again. But we feel confident the way the law is right now that it's on our side. Now, that's up to Mr. McGregor's attorneys to fight what they've got here. I'm on behalf of the sheriff, if a facility meets his rules and regulations, and if the machines meet his rules and regulations, he will issue the license, and they will be legal and operating. People forget the Constitution of the state of Alabama, in the amendment 744, says the sheriff shall promulgate rules and regulations. He's doing his constitutional duty. He has to do that, and he's done that.
Judge, may I ask you a question? How does, if there's a rehearing before the Supreme Court, and they again turn VictoryLand down, how does the case get from the state court to a federal court?
Well, that would be up to somebody that has standing. The sheriff wouldn't have standing on that. He may join in. We've tried to have a declaratory judgment here, of which has been shot down before. We've tried to get a factual finding like Judge Shashie found. Judge Shashie's finding is the first one that I know of where he said, I looked at everything, I heard the testimony, and, you know, it's dark outside instead of light. And so, you know, that's with legal manipulation after we go through this. But I want to remind everybody, what the Supreme Court said last week is not final. I mean, you have 14 days to file for a rehearing. So they can't do anything to VictoryLand's money or the machines right now until it becomes final. Then it's got to be sent back to the court. So we're here to say that the sheriff is here. He's doing his obligations, his duties under the Constitution, and he hasn't been ordered by anybody not to do anything. Now, if there's an order or something that goes to the sheriff, he's going to follow orders. He's a lawman.
Mr. Mack, would you reopen, you say you're going to try to reopen this summer?
Yes.
Before, if there is a rehearing before the Supreme Court, would you wait until the results of that, or do you intend to open in defiance of the Supreme Court order?
I intend to open.
All right.
I intend to open. I don't intend to open, we're going to open. Let me point out something to you I think is significant, especially the members of the media ought to focus on. Thursday was a week ago when I read about U.S. Attorney Beck writing that letter and asking these questions. I made a comment to one of my attorneys and to my wife. I can assure you within 2 weeks, the Supreme Court will issue a ruling to try to back up Luther on what he's done illegally. It didn't take 2 weeks, it took 6 days. 6 days. They were in such a hurry to issue that ruling to try to help Luther that they issued it on Thursday. They don't issue opinions on Thursday, they issue them on Friday. And the only opinion they've issued in recent history on Thursday was last Thursday. They had other opinions that came out this past Friday, just like they have in the past. So it's pretty obvious that there's some collusion going on there between those two bodies. And a lot of speculation on a number of things in that regard. But no question, we're going to reopen. And one other thing, and I'm not getting into the legal because I'm not a lawyer. I'm a shade. I spent so damn much time with these lawyers. I feel like I'm a lawyer, and I paid them so much money. But the bottom line is this. The bottom line is this. We asked strongly for oral arguments. Unprecedented. Not only did they not give us oral arguments, they didn't even tell us they wasn't going to give us oral arguments. And the reason they didn't want oral arguments is because they don't want you, the media, or the public to know the facts in a public setting where you could cover them. Oral arguments scared them to death. You wouldn't have been afraid of that if you were on the right side of the law. The only one that didn't participate in that ruling was Jim Maine. It was 8-0, and there's 9 on the court, as you well know. But that's some pretty significant facts that I just laid out to you there, and probably provides you with some things that you might want to ask some hard questions on. Yes, sir. Yes, sir. Down home.
Yes, sir, absolutely. The Supreme Court rules on the law, interprets the law. The Supreme Court does not necessarily enforce the law.
Right.
Previously, Governor Bentley ordered the Attorney General to get out of this and let it be at the local level with the sheriff and district attorney.
Right.
It would appear to me, and please correct me if I'm wrong, it's still ultimately whether, if you open, whether you get rated again is the decision, not of the Supreme Court, but again, the decision of the Attorney General. Is that a fair analysis?
The Attorney General? No, I don't think that is a fair. I think it's.
If he didn't, who would? Who could?
Right. Okay. Under the. Let me back up. Most of what you said, I agree with, except the last comment. I don't think it's a decision of the Attorney General, because under Executive Order, I think it was 13 that Governor Bentley issued earlier. Was it this year or last year? Wasn't it? Yeah. He took the issue back, and the way it happened before, when Riley, our opposition really liked it when Riley took over the bingo issue from Troy King. Well, Bentley took it back from the Attorney General as the Supreme Magistrate under the orders of the Supreme Court. So the opposition can't have it both ways. They like that because Riley was in office. Well, that's not the case now. So everything you said except the last part, but I can assure you this, I'm convinced of one thing, that we have as final law enforcement in this county as any county in America, okay? If we abide by the law and anybody interferes with our legal business, I think whoever interferes with our legal business is going to have a legal problem. I know they're going to have a problem with me, but I think they'll have a problem with the law. All right. I can assure you that we're working as hard as we can to get open and getting open in the proper way and having our facility. We're going to start interviewing people very, very soon and start hiring people very soon. And the question I think that you asked, Bob, one of the questions, we still got a couple of vendors, 2 or 3 maybe, that are intimidated of the illegal memorandum of understanding that Luther had them sign, forced them to sign. So we got to get that resolved with them, but we have other vendors that are not concerned, because they realize, their legal team have reviewed it, realize it's not worth the paper it's written on.
Have asked for what the sheriff requires, and we've given them updated requirements. So there's a lot of activity going on.
Yeah. As far as the number, as I said earlier, Mike, that'll be determined by, we can get as many machines as we need, but the number that we want here will be determined by the public, the demand of the public. And I hope that demand's high, and I believe it will be, based on the response since last summer when Judge Shashy ruled, on his first ruling and his second ruling, based on the response of the public, I think there'll be a high demand here for plenty of machines, and we're gonna have the latest. They are, as I said a little earlier, the machines that they ruled on last week were obsolete. We wouldn't use them if we got them today, and we're gonna have the latest versions that fall in the legal category of being electronic bingo machines. And by the way, there's over 80 locations in America that have electronic bingo machines. For a court to be intellectually dishonest and say there's no such thing as an electronic bingo machine is an insult to your intelligence. There's over 80 locations nationwide, California, Oklahoma, you name it, Florida. But any other questions?
How many are you gonna start with?
That is a good question, and I don't want to give you an exact number now because it'll depend on what happens in the next 2 or 3 weeks with some vendors. We're going to start, I'll put it this way, we'll start with several hundred, I can tell you that, and excuse me, and go from there. If I'm talking too loud, my wife says I talk too loud. I can't hear real good, I don't guess, but, and there's an echo here a little bit, but I apologize if I'm talking too loud for you. But I can't tell you exactly, but it'll be several hundred, I'll put it that way.
Mr. McGregor,
Yes, ma'am.
if you're comfortable with your legal position, why haven't you opened before now? Did you want to get through the Supreme Court case?
No, it's the reasons I've already given you.
Sir?
It's the reasons I've already given you. They destroyed our property.
Yes, sir. I know you said at one point you hope to be open by Christmas. Is it?
We didn't, yeah, but at that point, Ken, we didn't realize that they had gutted our property. Okay, when the contractors got in there, they pointed out, this is ridiculous. This looks like they came in here with one of the main purposes was to destroy your building. And it did a good job at that. We had to rewire, reconstruct, and that plus the illegal memorandums of understanding. If we hadn't had those two issues, we'd have been open before Christmas. Absolutely.
This might be a question for Mr. Anderson or the
Sure.
sheriff. If the Attorney General does attempt another action after reopening, we don't file some sort of complaint, go to court on, the Bentley demo, saying.
Well, I think that'd be for VictoryLand's lawyers to do, but he'd have to have some legal document. A search warrant. Last time, to get the raid, to give you a history on this, to get the raid, and the only reason we found out about this is because the orders that were written. But the Attorney General's office went to every judge in this whole area. They went to city judges, they went to all the circuit and district judges, and no one would sign a search warrant. and based on the representations that were being made. And then when the Judge Young wouldn't sign the search warrant, they went to the Court of Criminal Appeals. And the Court of Criminal Appeals unanimously upheld Judge Young and said, no, there's nothing, you can't get a search warrant. And then that was appealed to the Alabama Supreme Court, and they ordered Judge Young to give a search warrant. So that's how we got to this position. I don't think there hasn't been a judge, like I told you, I said that word, ore tennis, there hasn't been a judge on the ground that's heard the testimony, that's listened to it, that said there was anything illegal or anything different than what the Indians are doing.
You might,
Well, I think illegally, and you'll have to ask Victor and his lawyers, in the past, when the governor's task force came here in 2010, there was a protective order and the raid did not take place. And as I mentioned earlier, but we're not saying we're defying a order from the court. The sheriff is going to follow the law. He's a sworn officer. Until he is ordered and shown that something is illegal going on, it's going to pass his test in what he's had for his requirements for bingo, because that's his constitutional duty to do that.
the, one thing that y'all might want to take a hard look at is where these 8 Supreme Court justices and Luther got their campaign contributions. May want to take a hard look at that. Yeah. Especially the Riley money and the Indian money.
Take one more question.
All right, one more?
Got it? One more?
Yes, sir.
The day that this facility reopens, what's it going to be like for you to see this place bustling again?
Well, it's going to be a happy day, a real happy day, except for one thing. Mr. Willie Whitehead Sr. is not here. And that's sad. That's sad. Yeah. Other than that, utopia.